ஏன்னா எனக்கு கொடுக்கப்பட்ட டாபிக்ன்றது essentials of criminal trial. ஸோ அதில் மில்டன் சொன்னது restrict yourself to facts and issue and relevancy of facts, section 5, which I thought Honorable Justice Anand Venkatesh wouldn't touch, but now that he has touched it, so it will make it a little more relevant, and it will be a continuation of what Justice Anand Venkatesh had delivered in the morning. So this is not a lecture per se, because I'm not a professor, I'm a lawyer. So I'm just going to share my experience with you, and that will be of some help to you, because a quarter decade, both on the trial and the appellate side. So this will be in the perspective of a lawyer, and definitely not, you cannot expect anything from the perspective of a judge. The morning session is the perspective of a judge, and a very attractive and a good lawyer as well, but Tinga only from a perspective of a lawyer. So let me start by saying, what's a trial? See, criminal trial பொறுத்தவரையிலும் எங்க ஸ்டார்ட் ஆகுது, எங்க கல்மினேட் ஆகுது, what is the role of a lawyer, be it a prosecutor or be it a defense lawyer, and what exactly is expected out of a trial lawyer. That would be my general topic that is now to be presented. Now if you see criminal trial, we have to go to chapter 18 and 19. Chapter 18 deals with sessions trial, 19 deals with warrant cases, magisterial trial. So when a trial commences, what would be the role of a lawyer? So let's look at it from a perspective of a defense lawyer first, because prosecution, very few would be selected to go to prosecution. So most of us would be aspiring to become a defense lawyer on the criminal side. If that be so, what would be the duty cut out for a defense lawyer, and what should be his approach would be a paramount question in the minds of everyone around. See, interesting ஒரு trial என்னும்போது it is a tapas, it's an art, it is a penance, ஒரு தவம். Because ஒரு குற்றவாளி ஒரு வழக்கறிஞரிடம் வரும்பொழுது அவன் குற்றவாளியா இல்லையான்றது அவனுடைய கான்ஷியன்ஸுக்கு தெரியும், நமக்கு தெரியணுமா தெரிய வேண்டாமன்றது is a debatable question. Once you accept the brief, there are things that is expected out of a defense lawyer. Why I say this? Because Justice Anand Venkatesh, in a very recent judgment delivered in 2023, that is 3/4/2023 in Muthupandi versus State, has delivered a judgment expressing his displeasure. I'll read the relevant passages. அதை மட்டும் படிச்சுட்டு I'll start my session, I would say. Para 32 he says, at this juncture, this court has to necessarily record its displeasure in the manner in which the witnesses are cross-examined. On a daily basis, this court is able to find that the standard of cross-examination of witnesses has gone down drastically. It is quite unfortunate that the trial court advocates are not developing the skills of cross-examination. Most of the questions which are put to the witnesses are irrelevant and illogical. In the particular case, is the case of a rape. For instance, PW6 was examined in this case. A question was put to her and asked to explain as to whether hymen would rupture due to an insect bite. This would show the amount of ignorance on the part of the counsel on the human anatomy and medical jurisprudence. This is only a sample, and many such illogical questions are being noticed by this court on a daily basis. The trial court advocates must bear in mind that they are defending the right of a person guaranteed under Article 21 of the Constitution of India. Hence, it is their bounden duty to put appropriate questions during the cross-examination, failing which their client will lose his or her liberty by suffering a sentence. The art of cross-examination was considered as a crown in the advocacy skill. If this art is lost, the charm in conducting a trial before the court will also be lost. So this is what is expressed by a judge who also happened to be the speaker in the forenoon session or the chief guest. See, the art of cross-examination. See, as I said, trial is a penance. So then we have to equip ourselves to heed to the rigors and expectations of a penance. Now, there are two categories of lawyers. One, original thinkers, and two, who acquire knowledge, skills, and intelligence over a period of time. That will be decided over a period of time. At this juncture, as budding lawyers and lawyers who are aspiring to be defense lawyers on the criminal side, there are two things that are essential, apart from others. Two primordial things which are essential would be: one, creativity; two, knowledge of law. Knowledge of law is something which you have to acquire by constant reading. Creativity is something which is innate. If this creativity is not innate, it is not that you cannot develop creativity. Creativity can be acquired, can be developed over a period of time by experience, by seeing other eminent lawyers cross-examine, by reading other cross-examinations if you have an opportunity, and so on and so forth. So, in the rendu characters are essential for or to become a good criminal trial lawyer on the defense side. So now the question would be, how to put use of this creativity at the first place. For example, we have a case. On a day in and day out now, all the TV channels, they do a parallel investigation and a parallel trial. So the days, early days is not so, where unless and until you get the papers, read the facts, and the idu varadu. Ipo on the television all facts solliran. So, as budding lawyers, you have to set your imagination run now. The creativity starts. What could be the probable defense in a particular situation? Here is a case of a murder. What would be the defense? A creativity process start aganum. Imagination process start aganum. Now, after becoming a lawyer, when a brief is handed over to you, there are two things. One, read the facts thoroughly. Reading the facts thoroughly is for one simple purpose, that is to find out what is facts in issue, and two would be what would be the relevancy of facts. First, fact in issue is governed by Section 5. What is fact in issue? Let's not complicate. Let's go to the provision because this book is. So, issue is a disputed thing. What would be a fact in issue? So, let us say, take a classical case of murder. We'll take everything. We'll take corruption, we'll take 420, cheating, forgery, and all those things. Initially, let's take murder, which is easily understandable and relatable. One. In a case of a murder, there is a death caused because of homicidal violence. So, death is a fact. A person had died. So, how did the person die? In general, in a case of criminal trial, there are three things. It's either homicidal, suicidal, or it could be accidental. All three would fall within the ambit of a criminal trial. So, if it is homicidal, so we have a situation where a person is done to death because of an act of a person. Therefore, a case of murder can be registered. So the question is, the fact in issue would be, there is an overt act which has led to the cause of a death of a person, a homicidal death of a person. So this is a fact in issue. And that fact in issue can be stretched a little further. A commits the murder of B, and B dies in consequence of the overt act committed by A. Now, A is brought into the picture, B is dead, because of an overt act. So, in the situation, the fact in issue would be A murdering B and the B dying because of the act of the A. In the fact in issue needs to be proved before the court of law. Now the question of relevant facts. Now again I take back to the judgment of Honorable Justice Anand Venkatesh. He says irrelevant and illogical questions were put to the doctor. Now what is more important here is, now for us to create dots. So you already have 3 dots. There's a perpetrator of an offense. The dot B would be the person who is done to death, and dot C would be the overt act that caused to the death of. Now there are other dots to be connected. That may extend to up to Z, Z plus 1, so on and so forth. So in the dots and under the further provisions of law which says, I'll restrict myself only till, he says up to 55. Honorable Judge said in the morning that in the relevancy of facts, 55 I restrict myself to the first 5 provisions. That is, motive, Section 8 of the Evidence Act, motive, preparation, previous and subsequent conduct. So these are, though not facts in issue, these are relevant facts. Now let us stretch this 3 dots further. Motive, which comes ahead. So what led A to unleash an overt act on B is a motive. This is a relevant fact. Though not a fact in issue, it is a relevant fact. Second would be preparation. So how did he prepare himself to commit the murder of B? So that preparation comes under Section 8. And previous and subsequent conduct. Previous conduct, you could have started a fight or a quarrel. And subsequent conduct, you could have absconded himself, did something, threatened other witnesses and so on and so forth. There are subsequent conducts. There are so many dots now that forming part of the same transaction, though which is not at the same time. A motive could have happened a day earlier, even a month earlier, maybe a year earlier. It depends from the point of view of the person who has received that trigger to commit the offense. So if that be so, in the Sandarbhathala, we have to connect these dots. So second would be, this is in respect of Section 8. Now we touched upon Section 5, which the morning session they had led. I read Section 5. Evidence may be given of facts in issue and relevant facts. Evidence may be given in any suit, let's bar it, proceeding in an existence of or non-existence of every fact in issue of such other facts as hereinafter declared to be relevant and no others. I think the Honorable Judge made a beautiful explanation about it. So, those connecting dots must be made relevant by the person presenting it before the forum in a case of trial. Now, there are 2 things which I found it interesting. That is, the principal fact to be proved. Because, as my predecessor in the forenoon session had said, an offense, when an offense of murder is committed, for example, what is presented before the court, there are elements that are already stands proved. That is, a person had died due to an unnatural circumstance. So, if the police, after investigation, finds that the person had done to death or murdered, an offense of 302 has been committed, the charge sheet is presented for 302. So, under the circumstances, what are the issues relevant? Facts in issue would be that there will be an accused, there will be an overt act, and there will be a person dead because of homicidal violence, 302. So facts an issue. So what is presented before the challenge that is presented before a trial lawyer would be how to disprove it. Now, what would be the challenge before the prosecution would be how to prove it. So there is a lawyer who wants to make a point by saying, yes, this is a homicidal violence and this person who is before the court has committed the offense. His endeavor is to prove a fact. The duty of a defense lawyer would be to disprove a fact. So the principal fact is to be proved before the court of law, that is trial. That is factum probandum. Second would be factum probans, that is relevancy of facts. So what are the relevant facts? All these other circumstances, other dots that surrounding this principal fact needs to be proved. So in a case of a murder, motive should be proved, preparation should be proved. If there is subsequent conduct, that has to be proved independently so as to make a proper chain, so as to point towards the guilt of the person who now stands charged. How interesting if you see. Justice N. Dinaka, he was supposed to be one of the finest judges who presided over the criminal division bench of the Madras High Court. His judgments would be hardly 8 to 9 paragraphs, that's all, whatever be the case. I'm talking about where the facts are limited. Few paragraphs of facts, subsequently he'll go to 313 questioning. He'll say whether they have answered or it is just a simple denial. Then you would come immediately to the fact that the person who is dead is died due to homicidal violence. So it's a proved fact. So that's a fact and issue. Now, next, what you would contemplate would be whether the person now stands charged had committed the offense. So that is where the appreciation of evidence comes into play. Now, when it comes to appreciation of evidence, somebody was asking an interesting question this morning, cognizance. The cognizance is taken not against the offender, but for the offense. Offender could be anyone, but the cognizance is taken for the offense. So here is a case where section 5 talks about, as I read, facts and issue and relevancy of facts. And 6 more specifically talks about relevancy of facts forming part of the same transaction. And I skip 7, go to 8, which I had already read, motive, preparation, previous and subsequent conduct. I'll skip 9, I'll go to 10. 10 is an important section in this sequence of events insofar as criminal trial or an offense per se. Talks about conspiracy. Section 10 of the Evidence Act says, things said or done by conspirator in reference to common design. Where there is a reasonable ground to believe that 2 or more persons have conspired together to commit an offense or an actionable wrong, anything said, done, or written to be one of such persons in reference to the common intention, after the time when such intention was first entertained by any one of them, is a relevant fact as against each of the persons believed to be so conspiring, as well as for the purpose of proving the existence of conspiracy, as for the purpose of showing that. Let me say this. This is a very simple thing. It's an interesting question. Again, Justice Anand Venkatesan was there pretty much in this particular provision a couple of days back when I was making submissions whether some person could be brought within the ambit of conspiracy. He said, conspiracy is at a particular point in time. Hashed between, it's a common design entertained by 1 or 2 minds to execute a common object to commit an offense. So whether a person can be said to be a conspirator if he joins at a later point in time would be a moot question. Section 10 says no. The design must be at some point in time where all the minds meet, so in furtherance of a common design to execute an offense. அதை பின்னாடி பண்ண முடியுமா கேட்டால் unless and until adukkum edukkum proximity irukkanum. The relevant fact. I'll read that section again because this is a very interesting section which I thought would be of some use, where there is a reasonable ground to believe that two or more persons have conspired together to commit an offense or an actionable wrong. Anything said, done or written by any one such persons in reference to their common intention after that time when such intention was first entertained by any one of them is a relevant fact. So, and the inception என்றதை வந்து repeatedly அந்த இடத்துல யூஸ் பண்றாங்க. So the conspiracy, the design must be at some point in time, and whoever is said to be part of the conspiracy should jump into the bandwagon in execution of a common design at the relevant point in time. அதை பின்னாடி டெவலப் பண்ண முடியுமா? பின்னாடி suppose A, B, C conspires to do away with D. So they have fixed everything. Now, B informs E 5 days from the conspiracy, hey, எனக்கு ஒரு கத்தி வாங்கிட்டு வாடான்னு சொல்லும்போது அவன் கத்தி வாங்கிட்டு வந்து தரான். Can he be brought under the purview of the conspiracy? 120B எட்டுன்னு வர முடியுமான்னு கேட்டால், taking that into consideration, unless and until there is material to prove that he had the knowledge that he is buying that knife in furtherance of the conspiracy that is hatched 5 days ago between A, B and C. And the design, avanukku therinji, and furtherance of the execution of the design irundada, he could be brought under 120B. So, it is our defense lawyers look out to see whether the test of proximity or the connecting link is there between A, B and C and E to do away with D. So section 10 speaks about what is done by the conference in respect to a common design. So this is in respect of 10. So another interesting thing would be section 11. When facts and otherwise not relevant become relevant, அதில் வந்து செக்ஷன் 11ல ப்ரைமரியாக வர்றது வந்து alibi. Alibi in general in offenses relating to the presence of a person who perpetrates the offense, like bodily harm. So even if in case of impersonation, அந்த மாதிரி நேரத்தில் தான் the section 11 will come to play when the defense is taking a plea of alibi. Alibi is something which we all know the person is not there physically, he is physically present elsewhere when the offense is committed. That's alibi. So section 11 deals with alibi. So alibi பொறுத்த வரைக்கும் ரெண்டு விஷயம் நம்ம வந்து primarily we have to take into consideration. So we are trying to disprove a fact and issue. When A is charged of murdering B, when the defense says, no, A was not the person, it could be somebody else, because A was elsewhere, அப்படின்னு ஒரு plea எடுக்கும்போது, it is a plea which is diametrically opposite to the charge leveled against the person, then the burden of proof rests with the person who is taking a plea of alibi. So, alibi, section 11 பொறுத்த வரைக்கும், you are trying to disprove a fact and issue. So when you're trying to disprove a fact and issue, then you have to prove with material that this is a plea of alibi, I'm not here, and the burden of proof is very much with the defense. So now going back to section 9. Section 9 is respect of facts necessary to explain or introduce relevant facts. A fact to explain, introduce a fact and issue or a relevant fact, or which support or rebut an inference suggested by a fact and issue, or which establish the identity of anything or a person whose identity is relevant, or fix the time or place at which the fact and issue is relevant or what happened. So this is in respect of normally what we see is section identification of prisoners, identification of an accused, test identification. is brought within the, made admissible within the purview of this provision, section 9. So, identity of a person, whether a test identification is just an investigation tool. There are two things relating to test identification. One, it lends assurance to the investigating agency. These are words extracted from the Supreme Court's judgments. This is nothing but a reassurance that is given to the investigating agency that the person accused of is the person who had committed the offense, witnessed by a few of them. Avanga could be a stranger. So the process of test identification is conducted and these accused are presented before the magistrate to be identified by the witnesses. So whether is it a conclusive proof that they are the accused? Supreme Court has time and again held, no so, because test identification parade is nothing but a tool that lends assurance insofar as the identity of the accused. The identification of the accused in the court during the process of giving evidence is substantive. So, generally we cannot say that once a person is identified in the test identification parade, it doesn't mean that the person is the person who has committed the offense. So therefore, the provisions here, the relevant facts and the relevancy of things would come into play when the evidence is tested before the court or not otherwise. So we'll have to demarcate. There's a distinct demarcation between trial and investigation. So whatever is gathered, whatever material that is gathered during the course of investigation cannot be drubbed as evidence as meant under the Evidence Act. Those are investigation materials that are collected during investigation which has a character to be converted into evidence and they are not per se evidence. Those are materials. Now the question would be, when does these materials collected during the course of investigation assumes the character of evidence or becomes evidence? That would be during the course of trial. So now the question is, trial, as we said. So the trial insofar as murder is concerned, sessions trial is concerned, is governed by the provisions 225 to 235. Now there is a process, the process where the witnesses who have been examined during investigation, their statements under 161 or their statements for that matter under 164, all compiled along with other magazines and other material are placed before the court under 173, so clause 2, CRPC. Once those materials are placed before the court, it is for the judge to initiate the process, and the process of initiation would be under 235 and 236, we skip that. Then there is something called opening remarks by prosecution. I don't think that is practically done in any court. So it is for the prosecution to open their case. They'll have to place the material. They have to make opening statements. If anyone was well versed with all these legal dramas that is screened in these OTT platforms, and the English series, the prosecution will start by making a statement that this is the person who had committed the offense and this are the allegations leveled against them. And then the stage comes for the defense. But whatever that is let in during the course of investigation, it is for the defense who has an opportunity to see whether the offense alleged is substantiated legally by the material let in by the prosecution. There are two things. In a case of a murder, that may not be possible because there will be overtax, specific overtax attributed to individual accused if there are more than one. And if it is a solitary person, there's absolutely no chance because there is an allegation and there is a consequential death and therefore there's nothing scope. The scope of discharge is very much little. Even in a case of an murder, if somebody is charged with a lesser offense or aiding or abetting or subsequently harboring an accused or something, some kind of a misjoinder, these could be questioned under discharge. In the discharge provision of that is prior to framing of charges. So, once the defense realizes there is no scope for discharge of the accused that's facing the trial, the next step would be charging the person, which is a very important aspect whereby a person is charged. We'll take the provisions, we'll just scan through the provisions because it's there in the book, so we don't have to bother much. It starts at 225. So 227 is the provision which we use insofar as sessions trial for a discharge, and 228 framing of charges. Once the charges are framed, the next stage would be the most or the primary part of the trial, that is examination of witnesses. So the question of examining the witnesses, see, the provisions are, we have to go back to the Evidence Act from 137 on. So the order of examination, which is spoken to in the Evidence Act, would be under 135, and the order of examination per se would be under 137 on. So it is examination in chief, cross-examination, and re-examination. So chief examination is, now I'm trying to be very practical in this, I'm not trying to regurgitate whatever is there in the book. See, what is the role of a prosecutor in a case of permitting the witness to give his evidence in chief examination? The question would be, he has to make sure that the person who is giving evidence should support what he has said during his investigation, either under 161 or under 164. So 161, as you all know, it is not a signed statement. It is a statement that is reduced by an investigating officer, signed by the investigation officer. It can be used to corroborate or contradict the maker. Suppose if there is an omission which you think is in favor of the defense lawyer would ask such questions so as to corroborate what he has stated during the course of investigation. Or if he is giving some evidence which is likely to contradict, then to contradict the witness on those lines. There are two things which, similarly 164. 164 is nothing but a previous statement made under oath, signed by the person. And it is made before a judicial officer during the course of a judicial proceeding. Now the question would be, as my predecessor in session would say, it is not substantive. It is just a statement which is placed at a better pedestal than when compared to that of 161. That is all 164 is. This would be my view in considering the other things. Because there is a judgment which is judgment of the Supreme Court which had convicted a person based on 161 statements. So that can also happen. That's a different issue altogether. So whether 164 can be used to convict, in my humble opinion and in the view taken by the Honorable Supreme Court and the High Courts, no, it cannot be done. 164 is just another statement, a previous statement under oath. 164 can be used for other things. When 164, if a witness, if a public servant comes, gives a statement under 164, if he assails from that statement, if he gives a go-by, he can be penalized or prosecuted for perjury, for lying on oath. That is one thing where 164 has an edge. Now coming back to the chief and cross-examination. So once the chief examination is over, and another interesting aspect would be the prosecutor cannot lead the witness in chief examination, cannot put leading questions so as to get answers in chief examination. That is one more restriction that is placed on the prosecution. The witness has to give evidence in chief on his own volition. He cannot be led by the prosecutor. If he is led by the prosecutor, then the defense has the right to object. You are not supposed to lead. Let him speak on his own terms. This is one. Second comes the role of the defense. When it comes to the role of the defense lawyer has the right to lead the witness in cross-examination, to extract answers. Now the cross-examination is by itself, as I said, it's an art. So when it becomes an art, there are so many restrictions that is put so as to make sure the art is expressed in its richness. So cross-examination. Now the question would be, again we'll have to go back to section 5. Facts and issue, relevant facts. So, as a lawyer, as Honorable Judge said this morning, we'll have to keep reading this provision time and again to imbibe the simple fact for a better understanding of each and every case. What is the fact and issue and what is a relevant fact? So now I said a few words about a case of murder. The second would be a case of corruption, say for example a trap case. What would be the fact and issue? The fact and issue would be the trap proper. The trap would have a complaint. Under section 7 an FIR would be registered. Thereafter there would be an entrustment process where the decoy witness, so the person who wants the trap to be laid, is present along with the official witness so as to lend corroboration to that witness. And the money that is smeared with phenolphthalein, there's a procedure that is adopted. And all these things will form part of the entrustment procedure. After the entrustment, next comes the trap proper. When the trap proper is executed, that becomes a fact and issue. And the entrustment is a fact and issue, and the complaint is a fact and issue. Because the moment the demand and the complaint is registered, section 7 comes into play, that becomes a fact and issue. When the entrustment is done, that is yet another fact and issue because it enables the prosecution to show, look, these are the money that is now made a tainted money that should be paid to the person who demands it. So that becomes a fact and issue. When the money is parted, execution of trap in successfulness, then that becomes another fact and issue. When that tainted money goes into the hands of the accused, and when the raiding party comes and tests the hands of the accused for phenolphthalein by dipping it in a sodium bicarbonate solution and pick the solution turning pink, that becomes a fact and issue. Once the money is recovered, which is compared with the entrustment mortgagor, then the recovery is made, that becomes a fact and issue. So you have a series of facts and issue. So these facts and issue have to be disproved. How that can be done? Now, the moment your hand is tested for phenolphthalein, that means the trap is successful. Then what would be your defense? Now, the relevant facts, that is factum probens. The relevant facts that are not so connected in a way, but connected. So those facts are supposed to be brought into the picture. Now the prosecution has not gone forward with the truth always, because in a case of trap, there are things which are more than what is projected. There's something called thrusting, there's something called planting. These two are normal practices where if the prosecution believes that this person is not going to accept the money, maybe he would have gotten a hint, he may be corrupt, but he would have gotten a hint that the prosecution is coming to raid them, the investigation agency is coming to raid them by trapping them, then he may not accept. And there are innocent persons who would not have demanded money, but some ulterior motive by the decoy, de facto complainant, he may give a false complaint, and the investigating agency is compelled to make the trap successful. They would either trust it, or thrusting in the sense, try to push it into the hands, or plant it and thereafter plant it somewhere nearby the accused, and thereafter say that the money was received by them and kept him. There are other methodologies. These are instructions that you receive before you go into the trial. So, ultimately, the fact in issue has to be disproved by your talent, your creativity, your imagination based on the instructions that you take. So therefore, the relevant facts to disprove the facts in issue are now to be dealt in cross-examination. So cross-examination has its own restrictions from 145 to almost 152. Those are the restrictions which are reasonable according to law that are laid so as to enable for the defense to do a cross-examination which is in accordance with law. So this would be the provisions which you have to by heart. That is 146 is the questions lawful in cross-examination. 147 of the Evidence Act would say when witnesses will be compelled to answer. 149 puts an embargo, questions not to be asked without reasonable grounds. 150, procedure of the court in case of the question being asked without reasonable grounds. 151, indecent and scandalous questions. 152, questions intended to insult or annoy. These are things to be avoided. Now, when it comes to cross-examination, as I said, it's an art. Beating around the bush is one thing. I can cross-examine the witness for 10 days straight and yet will not be able to get even a single answer to disprove or dispute the facts in issue. But at the same time, if you're thorough with your cross-examination, with your facts, if you're thorough with law, you can go straight, hit the nail on its head by asking restricted questions which would go to the root of the case or the root of the fact in issue. Thereafter, unsettle it and disprove it so as to impress upon the court into appreciating the evidence that is tendered. That's one thing. The second thing would be giving an alternative theory. Alternative theory, suggestive value, where there are so many questions, suggestions are put to the witnesses. See, nowadays, being an appellate side lawyer, now when the first and foremost question would be from the judge, have you suggested this to your witness? See, you may have an alternative theory. You may have a different fact, relevant fact, which is going against the fact in issue. That has to be put to the witness during the cross-examination. You're not going to get a direct answer. If you're going to get a direct answer, then you're the best of the lot. But you can suggest your relevant, the questions that are relevant to disprove the fact in issue. If he is going to deny, it assumes a character of a suggestion. So suggestions are not just mere suggestions. I do not know how many of you had gone through murder trials where suggestions are put to the witnesses. The suggestive value, the value of the suggestions that are put are not just ceremonial, but it has its own meaning and it has its own defense. I think I just want to repeat this again. There's an interesting case law. It's a case relating to a murder of a lawyer that happened in Karnataka. The body was dumped in Salem. This cross-examination I was interested to read the bundle in my nascent stages of my career. So my senior, Mr. V. Gopinath, senior advocate, made me read the entire bundle and called me once and he said, Sathyan, have you read the cross-examination of these things? He said 3 particular witnesses. See, the case is this. This lawyer from Kerala, one Rashid, had gone to Karnataka and he was creating trouble insofar as the issuance of license to a college in which a former minister had a role in it, had its own interest in the college. And the case is, the police were used to pick this person up, and during the process, the police bet the person with all the harshness that they could. We stop the story for a moment, and thereafter, the body of the person was found near a barren land, a bushy land, near Salem, between 2 stations. I think one is Omalur, another one I do not know, X and Y. So now the prosecution case is that after the CBI took over, after so many things, the state police investigated, Karnataka police investigated, the Tamil Nadu, the Salem RPF investigated and put together, since high-profile persons were involved, the matter was entrusted to CBI. And CBI came forward with a story, or a prosecution case, I would say, that the person was brought in a jeep from Karnataka. He was assaulted, he was bleeding his way to death, and the jeep was brought into a place where the body was dumped that was around 50 meters from the track. So therefore, the prosecution said it is the police who did it at the behest of some political person to protect the interests of an institution. That is the case. Now the defense came forward with a theory. The theory was, Rashid did everything in Karnataka. Thereafter, he was on the way to Kerala. So he decided to go to Kerala by train. So when he was crossing X and Y station, he was standing on the footboard where he fell and he died. That was the defense version of it. Now, the lawyer who does the cross-examination. So as I always say, lawyer is a jack of all the trades. He must know everything. When he is confronting a doctor, he must know, or at least know, how to pretend that he knows something more than the doctor does. So when he is confronting an expert of a particular field, he must pretend that he knows a little more than the person who is going to confront. So lawyer is a person who is supposed to know everything. So that is why we kept on a lawyer na periya kumbanu. Ama periya kumbu da. ஏன்னா உன்னை விட எனக்கு ஒரு படி அதிகமாக தெரியுன்றது தான் லாயருக்கு இருக்க வேண்டிய அந்த திமிர். அந்த திமிருக்கு இந்த ஒரு கேஸ் உதாரணம். ஏன்னா அந்த லாயர் கிராஸ் எக்ஸாமின் பண்ணுறாரு. அந்த லாயர் யார் நான் அப்புறமா சொல்கிறேன். என்ன கேட்டாங்க, என்ன எங்கள் சீனியர் என்ன கேட்டபோது நான் சொன்னேன், ஒன்றும் பெருசாக இல்லை சார் கிராஸ் எக்ஸாமினேஷன், இல்லை போய் படிச்சுட்டு வாங்க இன்னொரு வாட்டினார். மை சீனியர் இஸ் வெரி சர்காஸ்டிக் அண்ட் அட் டைம்ஸ் வெரி ஹார்ஷ் ஆல்சோ. இப்போ ஒழுங்காக படிங்க சார், படிச்சுட்டு வந்துட்டு இப்போ பேசுங்க சார்னார். சரின்னு போயிட்டேன். அப்போ என்னுடைய மூளைக்கு ஏறல, பிகாஸ் ஐ வாஸ் ஸ்டில் at the nascent stage of my career. So he asked the first witness, somewhere around 35, 36, PW 35, this happened some 20 years back, 23 years back. He asked PW 35, X station Y station varaikkum the train enna vegathila cross aachunu. He says it crossed on, it had 80 to 85 km speed under the recorded evidence in cross-examination. No further questions. Rende question on the witness mudijiruchu. Adutha question vararu timekeeper kitta. enna இந்த டைம் இந்த ஸ்டேஷனுக்கும் அந்த ஸ்டேஷனில் கிளாக் ஆன டைம் என்னன்னு அவர் ஒரு பர்டிகுலர் டைம் தரார். இதுலேருந்து it corroborates the evidence of PW, the earlier witnesses who would say the train travelled in a particular speed. அந்த விட்னஸ் கிட்டேயே கேட்குறாரு. அந்த இடத்துல இந்த போஸ்ட் every pillar will have a number. So the practical knowledge of the topography. A lawyer goes there, ஒரு கேங்மேன் பண்ண வேண்டிய வேலையை பார்க்குறாரு. எங்கே என்ன பில்லர் இருக்குது, அது என்ன இருக்குது, இது எங்கே என்ன இருக்குது பார்க்குறாரு. ஸோ அங்கே போய் பார்க்கும்போது இந்த பில்லர்கிட்ட ஒரு கர்வ் இருக்கான்ற. ஆமாம், அந்த பில்லர்கிட்ட ஒரு கர்வ் இருக்கும். சரி, அது ஒரு நிகழ்ச்சி cross examination. நெக்ஸ்ட் கம்ஸ் த இன்ஜினியர். அந்த இன்ஜினியர்கிட்ட கேள்வி ஜென்ரலாக ஒரு 2-3 கேள்வி கேட்குறாரு. அதே கேள்வி தான் கேட்குறாரு, இந்த இடத்துல அந்த கர்வ் வருதா எல்லாம் வருதான்னு. தென் application of physics. What is the speed at which the train was traveling? In the engineering, it was traveling around 85 to 90 kilometers per speed, sir. What is the force exerted on either side of the train when the train is traveling in a straight line? He says centripetal force. Centripetal force. What is the force exerted on the other side? Centripetal force exerted. What if I throw a thing from the door? What will happen to that object? He says it will be sucked into the track, under the wheels. Sorry. Next question. What is the force exerted when the train is moving on a curve? He says centrifugal force. A 70 kilogram person, a train traveling at, what is the speed? Does the speed reduce? He says no. Speed doesn't reduce because timing irukku, and that is just the curve of this deviation. Okay, fine. In the degree தான் அந்த curve இருக்கு. சரின்னு சொல்லிட்டு ஒன்று என்ன சொல்கிறாரு? Okay. What is the force exerted when there is moving on a curve? On the curve, the force exerted is centrifugal force. What happens to an object which is 75 kilograms? It's dropped from. It is thrown out. அதோடு நிறுத்துறாரு அந்த cross-examination. So, the cross-examination, the relevant fact, these are not facts in issue. Relevancy of facts, though distantly connected. It is not at all unconnected. It is not connected. It is not a relevant fact at all. It is so distantly connected, he is trying to establish the connection between a fact and the fact in issue. Now, the story goes like this. The person was on the footboard. The train was traveling in a curve. He slipped and fell down. He was thrown out 50 meters. So he would conclude his defense by saying it is a case of accident, not a case of murder as suggested by the prosecution. The person who conducted the cross-examination is none other than senior advocate Mr. Ramjit Malani. அவருடைய cross-examination புரிஞ்சுக்கிறதுக்கு எனக்கு அறிவு கிடையாது. அதை 10 வாட்டி படித்ததுக்கப்புறம் தான் புரியும். Ramjit Malani is a man of few words, but on the application of physics in a murder trial, Justice Dinagar அதை படித்து பார்த்துட்டு சிரிச்சுட்டு தூக்கி போட்டார். It took him 5 minutes to dispose of this case, which is almost 20 volumes. What is this case of accident? அது தூக்கி போட்டார் கிட்ட. So that is the art of cross-examination. So, now coming back, இந்த கதையை விட்டுடுவோம். I think we'll go back to the provisions of law. Now in a case of trap, so let's come into the question of trap cases. High Court ஒரு கேள்வி கேட்பாங்க. Now answer, the ஒரே கேள்வி தான். See, there will be pages and pages of cross-examination. பக்கமாக cross-examine பண்ணிட்டு நான் டிஃபென்ஸ் லாயரும் கால் கெடுக்க நின்று படிக்கணும். ஜட்ஜும் தூங்கிட்டே தான் கேட்பாரு. I do not know how many of you are sleeping because I don't see anyone sleeping, glad. Except Milton was sleeping for some time. So, நான் சொல்லியிருக்கேன். So, what happens? Here, trap கேஸை படிக்கும்போது decoy witnessையும் அதையும் மாற்றி கேள்வி கேட்டுருப்போம். See, money would have been recovered from his hand. His hand would have tested positive for phenolphthalein. It would have turned pink bicarbonate. Judge ஒரே கேள்வி. Answer this simple question. Stop beating around the bush. Let us know how did his hand turn pink. இதை மட்டும் சொல்லுங்கள், கேஸ் சொல்கிறோம். So, everything, நீங்கள் எவ்வளோதான் நீங்கள் cross-examination பண்ணாலும், that particular fact that you're trying to bring in, though it may be relevant, it may sound irrelevant or distantly relevant, அந்த பர்டிகுலரில் வந்து நம்ம கதை சொல்லணும். இதுக்கு 2-3 எக்ஸ்ப்ளனேஷன் சொல்லலாங்க. நார்மலாக சீனியர்ஸுக்கெலாம் தெரியும், ஸ்டாண்டர்டாக அந்த காலத்தில் வந்து ஃப்ளாக் டே கலெக்ஷனுக்காக வாங்கணும் அப்படின்னு ஒரு டிஃபரன்ஸ் எடுக்குவாங்க. ஸோ யூ ஹாவ் டு மேக் அன் எக்ஸ்ப்ளனேஷன் ஆஸ் டு வை. தட் இஸ் தி சில்வர் லைன். அவ்வளோதான். அந்த எவ்வளோ பெரிய கேஸாக இருந்தாலும் we will be able to explain as to how did the money reach your hand and that prompted the chemical reaction in your hand என்றது மட்டும் தான் நீங்கள் ஆன்சர் பண்ணணும். ஸோ அதுக்கு இன்ஸ்ட்ரக்ஷன் இஸ் இம்பார்ட்டண்ட். செகண்ட், ஸ்ட்ரக்சரிங் ஆஃப் யுவர் cross examination. How do you understand the case? Perception of the case, facts. ஒன்ஸ் ஒரு கேஸை படிக்கிறோன்னா அத்தனையும் மண்டையில் எழுதி வச்சுக்கணும். அவ்வளோதான். ஒரு பக்கம் ஃபேக்ட்ஸ் நீட் ட்ராக் ஒன்று போட்டுடணும். போட்டுட்டு keep assimilating. Adhiye keep thinking. You have to regurgitate, keep chewing. What the cows, ruminants does, we have to do that. Constantly பண்ணிட்டே இருக்கும்போது எங்கேயா இடத்துல ஒரு ஸ்பார்க் கிடைக்கும். இன்ஸ்ட்ரக்ஷன்ஸ் இஸ் மோர் இம்பார்ட்டன்ட். ட்ரையல் என்ன இன்ஸ்ட்ரக்ஷன்ஸ் கொடுக்குறாங்க கிளையண்ட், அவன் சொல்லுவான், இல்லை சார் நான் வாங்கலை, வந்தார் பேசிகிட்டே இருந்த டேபிள் ரால் அப்படி வச்சார், என்னையா வைக்கிறேன்னு எடுத்து தூக்கி போட்டேன், வந்து போலீஸ் பிடிச்சிட்டாங்க. So, provided factually you have to correlate. Now the facts and issue come into play. Suppose if your defense suggested by your or instructed by your client that இந்த கதையை சொன்னார், வச்சார் சார், ஏன்டா பணத்தை வைக்கிறேன்னு தள்ள அந்த பணத்தை கீழே சொல்லிட்டாங்க. அதே மாதிரி ரெக்கவரி மகஜரில் if your right hand alone had tested positive of phenolphthalein, then you take the defense, because that is the defense. ரெண்டு கையும் பிங்காக மாறினதுக்கப்புறம் ஒரு கையில் தள்ளன்னு சொல்கிறான்னா போய் சொல்கிறான். ஸோ தோஸ் ஆர் ரிலவென்ட் ஃபேக்ட்ஸ், த ரிலவன்சி ஆஃப் ஃபேக்ட்ஸ். ஸோ இந்த சின்ன விஷயங்கள், தீஸ் ஆர் நுவன்சஸ் இன் ட்ரையல். அதை மறந்துட்டு போயிட்டு நம்ம வந்து இஷ்டத்துக்கு டிஃபென்ஸ் எடுக்க முடியாது. ஒரு சில கேஸில் வந்து ஒரு அருமையான கேஸ் where I think Justice Armu Perumalathan was at that relevant point, he was the judge. He was so impressed. என்னென்னா கேஸ் என்னென்னா, ஒரு இன்ஸ்பெக்டர் ஆஃப் போலீஸ், there was a assault, the person sustains grievous injuries, he was hospitalized, but a case was registered only for 323. என்னென்னா 10,000 ரூபா demand to convert the case from 323 to 326. இதுதான் demand. கேஸ் என்னென்னா, கவரில் 10,000 ரூபா எடுத்துன்னு போய் கொடுத்ததா கேஸு. காரிடாரில் வந்து போலீஸ்காரர் நடந்துகிட்ருக்காரு. பிகாஸ் இதோட இன்ட்ரெஸ்டிங் கேஸஸ் விச் ஐ ரிமெம்பர். நடந்துகிட்ருக்காரு. 10,000 ரூபா கவரில் போட்டு கொடுக்குறாங்க. கொடுத்த உடனே அவர் வாங்கிக்கிறாரு. எங்களுடைய கேஸ் என்னென்னா, பணத்தில் தான் நீ ஸ்பேர் பண்ண முடியும், ஃபினாப்தலின்னா கவரில் பண்ண முடியாது. எங்களுடைய டிஃபென்ஸ், அவன் 324 அந்த கிரீவியஸ் ஹர்ட்ஸ் இன்ஜுரிஸ் இந்த சர்டிஃபிகேட்டை வந்து ஆக்சிடென்ட் ரெஜிஸ்டரையும் வூண்ட் சர்டிஃபிகேட்டையும் கொடுத்து அனுப்புகிறதா சொன்னாங்க. அதை ஒருத்தன் வாங்கிட்டு வந்து கொடுப்பான், அதை வாங்கிக்குவோன்னாங்க. அதை தான் நான் வாங்கினேன்றது கேஸ். பட் ஹவு டிட் யூ ஹேண்ட் டெஸ்டட் பாசிட்டிவ் ஃபார் ஃபினாப்தலின்னு ஒரு கேள்வி வந்துச்சு. எங்களுடைய டிஃபென்ஸ் கவர்லேயே தடவி கொடுத்தாங்க, ட்ராப் பண்ணோன்றது எங்களுடைய இன்டென்ஷன். எல்லாம் நல்லபடியாக போயிருந்துச்சு, முடிஞ்சிடுச்சு. லன்ச் டைம், வாட்ஸ் இஸ் ஆன்சர்ன்ற 3:13 நான் பார்த்து சொல்கிறேங்கன்னா லஞ்சுக்கு போயிட்டு வந்தாச்சு. 3:13 திறந்து பார்த்தா டேபிள் ட்ராயில் வச்சுட்டு போனாங்கன்னு ஒரு டிஃபென்ஸ் எடுத்து வச்சுருக்காங்க. We didn't know what to do because such a wonderful cross-examination, beautiful travel of the cross-examination. 3:13 கொள்ளும்போது டேபிளுக்கு கீழே வச்சுட்டு போயிட்டாரு, அதை நான் எடுத்ததுனால கையில் பிங்க் ஆகிடுச்சின்னு ஒரு கதை. ஸோ 2 different diametrically opposite stands. வந்த உடனே வாட் டிட் யூ சே, லெட்ஸ் டிக்டேட் ஜட்ஜ்மெண்ட்னார். இல்லைங்க 3:13 இந்த மாதிரி ஸ்டாண்ட் இருக்கணும்னு அப்படியே தலையை 2 வாட்டி பிடிச்சிட்டு யார் கிராஸ்ன்னாரு. பேரை பார்த்தாரு. ஐ டோன்ட் வாண்ட் டு சே எனிதிங் மோர், ஐ வில் ஹேவ் டு கன்விக்ட்னாரு. ஸோ இந்த சின்ன விஷயங்கள், see as an appellate side lawyer, because I always give credit to the trial lawyer. If I'm going to handle an appeal, I don't take the credit at all, because அவங்க சமைச்சு வச்சதை ஒரு appellate side lawyer பரிமாறுறான். Ultimately the trial lawyer takes the cake, because he is the master chef. அவர் என்ன நல்லா சமைச்சு வைக்கிறாரோ நான் அதை ஃபேன்சிஃபுல்லாக பரிமாறலாம். If he doesn't cook well, நான் என்ன தான் டேஸ்ட்டாக பரிமாறினாலும் அது எந்த உப்பு சப்பு இல்லாத பொருளாக தான் இருக்க போகுது. ஸோ இட்ஸ் அல்டிமேட்லி இட் இஸ் த ட்ரையல் லாயர் who is the master, he is the master chef, he is the artist. So an appellate side lawyer is just a marketeer of the art, nothing more. I can only market the art. So the next stage would be your concentration and focus. So as I said, chief, cross-examination, suggestions, suggestive values, idallam potittu. Next, in case of thing would be re-examination for the prosecution. Re-examination, they try to clarify if at all there is any doubt. Some ambiguity, something that we try to shatter the prosecution will try to clarify certain things on facts. அதுக்கப்புறம் ரீக்கப்புறமும் ஒரு கிராஸ் நமக்கு ஒரு ஆப்பர்ச்சுனிட்டி இருக்குது. அது ஏன்னா கோடில் இல்லை, பட் பிரின்சிபல்ஸ் ஆஃப் நேச்சுரல் ஜஸ்டிஸ் அங்கே வில் கம் இன் டு பிளே. கிராஸுக்கு அப்புறம் தேர்ஸ் அ கொஸ்டின் வெதர் தேர் இஸ் அ ரீக்ராஸ் எக்ஸாமினேஷன் இன் எவிடன்ஸ் ஆக்ட். தேர் இஸ் நோ ப்ரொவிஷன் ஃபார் ரீக்ராஸ் எக்ஸாமினேஷன். Chief, cross and re-examination. If in case, if you get an assertive answer in cross-examination which the prosecution wants to re-examine and clarify that, then we'll be given an opportunity, which is just principles of natural justice. It's not an evidence act too. The next stage would be, after the chief and cross-examination, is 313. What would be the role of a lawyer under 313? 313, time and again, Supreme Court has said it's not an empty formality. It is not a ceremonious thing. 313, where incriminating circumstances that are brought forth by the prosecution during the course of trial is put to the witnesses so as to enable them to answer it. இது ரொம்ப ஒரு முக்கியமான ஒரு ஸ்டெப் இன் ட்ரையல். So, as lawyers, what we have now in our mind, or what we are supposed to have in our mind would be the facts. Adanode role overrides. Now the evidence should be replacing the facts that are placed before the court, founded out from the 161 statements. Charge sheet lagar facts vandu, it is now in an elevated form of evidence. இப்போ மண்டையில் எவிடன்ஸ் மட்டும்தான் இருக்கணும், அதை 161 மரத்தை தூக்கி ஓரமாக வச்சிடணும். அந்த ஃபேக்ட்ஸ் எவிடென்ஷியரி ஃபேக்ட்ஸ்லேருந்து வாட் இஸ் இன்கிரிமினேட்டிங் ஹேஸ் டு பி கல்ட் அவுட் அண்ட் தேர் ஆஃப்டர் பிளேஸ்ட் ஆஸ் incriminating materials. For PW1 says this, PW2 says this, PW3 says this. இதெல்லாம் சொல்லிக்கிட்டே வரும்போது he should be able to answer. In a case where there is no presumption or legal presumption, and a case where there is legal presumption, there are two different things. Normally in a case of murder, the answer would be a total denial. What is your answer in 313? It's a case of gross denial, my lord. That's all. Nothing more to add. Anga vandu certain things are compelled the accused to give answers. Under what circumstances? There, section 108, 106. 106 is special knowledge. This is an interesting case, Papa. It is a failed case though. A famous hotelier abducted the employee after he had a lustful relationship with the wife of the employee. Satham kettichu adha. So, enna aiduchuna, defense trial kulla poranga, abduction varaikum proved. He was forcefully abducted by a group of men in a car. Thereafter what happened என்றது கேள்வி. அந்த ஸ்டேஜ் வரைக்கும் ட்ரையலில் அட்மிஷனில் போயிட்டு அதுக்கு அடுத்த ஸ்டேஜில் வந்து டினையலில் போயிடுது. They don't offer any explanation as to what happened under 313. Or for that matter, during the course of trial, suggestions வந்து கம்மியாகிட்டே போகுது, என்னன்னு சொல்ல வரல. அந்த ஸ்டேஜில் தான் செக்ஷன் 106 ஸ்பெஷல் நாலேஜ் கம்ஸ் டு பிளே. 106, if you have Evidence Act, please take. It is a tricky proposition. அதனால தான் அங்கங்கே டச் பண்ணிட்டுருக்கேன். Burden of proving fact, especially within the knowledge. Any fact is especially within the knowledge of any person, the burden of proving that fact is upon him. ரெண்டு விஷயம். In a case of dowry death, which is very common and rampant, and most of you are budding by the stage you reach to a level where you will be handling sessions trial, உங்களுக்கு கண்டிப்பாக அது வேணும். ஹஸ்பண்ட் தூங்கிட்டு இருப்பார், சண்டை போட்டுட்டு கம்ஃபர்டபுளாக தூங்கிட்டு இருப்பார். ஒய்ஃப் இருக்கிற கட்டுப்பெல்லாம் காமிச்சிட்டு போய் ஷீ வில் கமிட் சூசைட் either by self-immolation or hanging, consuming poison or whatever be. 313 கேள்வி வரும். ட்ரையலில் போகும்போது ஒரு ஸ்டாண்ட் எடுப்பாங்க, ஒன்றுமே இருக்காது, டினாயிலே போயிட்டு இருப்பாங்க. 313 என்னன்னு கேட்டிங்கன்னா ஒன்றும் சொல்ல முடியாது. There is a presumption raised that you are supposed to answer to say what happened there, because it is within the four walls. The knowledge, the special knowledge is attributed to you. நீ இருக்க சண்டை போட்ட இவ்வளோ பிரச்சனையானதுக்கப்புறம் இல்லை நான் தூங்கிட்டேன் என்ன ஆச்சுன்னு தெரியாதுன்னு சொல்ல முடியாது. ஸோ இன் அ கேஸ் ஆஃப் டவுரி டெத்னு பார்த்தீங்கன்னா அது 3 சர்க்கம்ஸ்டான்சஸ் வரும். எனி அன்நேச்சுரல் டெத் அது அப்படின்னு வந்துருச்சுன்னா இட் குட் பி அ சூசைட், இட் குட் பி அ assault thereafter coupled with suicide, or something which pushed her to the extent of committing suicide. Or it could be a murder, or it could be an ambiguous thing, because some things, a murder can mimic a suicide can mimic a murder, either way. And the exigencies எல்லாம் பார்த்து தான் unnatural deathனு 304Bல எடுத்துகிட்டு வந்து வச்சுட்டாங்க. So you have to answer. Though there is no presumption, the situation so compels you that you need to give an answer. You need to give an answer. So 313 as I said, it's not an empty formality. இப்போ unusually most of you may even become magistrates, direct sessions judges, ultimately one day become, because I'm just restricting myself to magistrates and session judges, where you will be exposed to the rigors of the provisions of law in its practical applications. Unlike high court judges, they just sit and say what is wrong and what is right and more, that's all. அங்கே தான் ஃபவுண்டேஷன். ஸோ அந்த சர்க்கம்ஸ்டான்சஸில் 313 வரும்போது ஆசா 1 நான் இந்த ஊரில் பிறந்த எல்லா கதையும் சொல்லிவிட்டு முடிச்சிருவாங்க. அப்படி பண்ணலாமான்னு கேட்டால் தப்புப்படி பண்ண முடியாது. 313 has to be focused. டைம் அண்ட் அகெயின் சுப்ரீம் கோர்ட் 100 வாட்டி சொன்னாலும் எனக்கு தெரிஞ்சு வெரி 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 ஃபியூ, a handful of judges எனக்கு தெரிஞ்ச வரைக்கும் they do 313 in the proper sense, for the simple reason they think it's just a ceremonial, it's just a formality. It is not so. You are trying to put the accused to the relevant incriminating circumstance that has been pitted against him during the course of trial. அதை மட்டும்தான் எடுத்துட்டு கல் அவுட் பண்ணிட்டு போனோம். There are two things. I'm not going to blame the judges in toto, because of the simple reason, the workload. 12:45 மணி வரைக்கும் காலிங் ஒர்க்கை முடிச்சுட்டு அதுக்கப்புறம் 5 ட்ரையலை முடிச்சுட்டு நாம்ஸை கம்ப்ளீட் பண்ணோம் பார்த்தா ப்ராக்டிக்கலாக நாட் பாசிபிள். 313 is normally typed by the stenographer. I don't expect them to have any legal knowledge. So it is a role that should be executed by the magistrate or the judge himself or herself, where அந்த 313 அதை கல் அவுட் பண்ணணும். இதுதான் இன்கிரிமினேட்டிங் சர்க்கம்ஸ்டான்ஸ், இதுக்கு நீங்கள் என்ன சொல்கிறீங்க. அவன் தப்பாக சொன்னான்னா அவன் கதை முடிஞ்சது, கரெக்டாக சொன்னான்னா ஃபைன். தட் இஸ் ஹவ் 313 takes its most important position in the thing. And another part of 313 is 314 ஸ்டேட்மெண்ட் போடுறது. Statement is your defense statement. You cannot take one particular stand in trial and give a different version in your statement under 314. It should be in consonance. எனக்கு தெரிஞ்சு நாங்கள் என் சீனியரோட நான் ட்ரையலுக்கு அக்கம்பெனி பண்ணும்போதெல்லாம் 313 we used to add documents which may not be tested during the course of trial. And the documents they consider as circumstances but not evidence as such. But they used to rely on it and do it. Now the Supreme Court strictly said, don't rely on any document that is appended with your 314 statement. It is no longer in vogue. So unless and until it is tested during the course of trial. If you're going to let in as a defense document by the prosecution, if it's going to be from the prosecution to by the defense witness, it is not a material to be considered. இங்கே தான் ரோல் முடியுதா இல்லை ஒன்று ஸ்டேஜ் தள்ளி போகிறோம். டிஃபென்ஸ் விட்னஸஸ். டிஃபென்ஸ் விட்னஸஸை எப்படி ஏற்றுறோன்றது தான் கேள்வி. ஸோ இட் இஸ் நாட் just an empty or something, a fanciful exercise where defense witnesses are brought in. Defense witnesses நம்ம போடும்போது you will have to be absolutely careful. Defense witnesses பொறுத்த வரைக்கும் ஒரு adverse evidence, if it emanates from a defense witness, that will blow the death knell for your case. Unless and until you are confident about your witnesses to be examined in defense, you should not let in. So therefore, on the defense witness stage, உங்களுடைய job முடிஞ்சிருச்சு. Then it is all left to the judge to decide the case. Of course, arguments is going to be based on what is elicited during cross-examination. So, these are all the dots that a defense lawyer has to cover during his role as a defense lawyer. And for the prosecutor is how well he presents the investigation. Prosecutor is always a prosecutor. He cannot take a role of a persecutor. Prosecution என்ன பண்ணுதோ உங்களுடைய மைண்டையும் அப்ளை பண்ணணும். பிளைண்டாக பண்ணவும் கூடாது. So prosecutor has his own limitations, but he cannot be having his free hand because நாளைக்கு he is also answerable from his director of prosecutions. நீங்கள் ஏன் சார் இப்படி பண்ணீங்கன்னு ஒரு கேள்வி கேட்பாங்க. ஸோ அவங்க ரோலை அவங்க பண்ணணும். So these are some of the aspects of trial.